Good morning. We're on the record. S-1-SC-40442 Moreno versus Ranger Energy Services. Petitioner, you have 25 minutes, 5 on rebuttal. You may enter your appearance and proceed.
Good morning, Chief Justice Thompson and honors. Please support Rosalind Bienvenue and Karen Friedman on behalf of plaintiff petitioner Jesus Moreno. Last year in Zingara, this court reaffirmed the important purpose of our savings statute, which is to facilitate the resolution of disputes on their merits. And the court emphasized its steady focus on protecting a plaintiff's substantive rights by providing leniency when a case fails for some non-merits recourse. To that end, Zingara confirmed that the negligence and prosecution exception to the general savings provision is very narrow. Negligence in prosecution just means one thing. It just means actual failure to prosecute or failure to take the steps necessary to bring the pursuit to a close. Here, plaintiff was trying to vindicate his substantive rights, but his case was dismissed because of a procedural defect, that he did not fail to prosecute the first case, and the dismissal was not for failure to prosecute. Still, the Court of Appeals held that the negligence in prosecution exception.
But it was dismissed because of failure to comply with statute of limitations, correct?
Yes, the first.
So why, this is a question that's been on my mind, under the savings statute, why was not the first case in Colorado prosecuted because of negligence, failure to prosecute because of its negligence?
I'm sorry.
Negligence in its prosecution is the phrase from the statute.
Yes.
So was there negligence in prosecuting the Colorado action by failure to comply with statute of limitations?
No, that is not a failure to prosecute within the meaning of
Why not?
The savings statute. I think the court in Zingara was quite clear that dismissal for negligence in prosecution is just failure to prosecute, which means you have brought your case, you have taken no steps whatsoever to move your case forward, and you were dismissed for that.
Not filing the case is failure to take action.
Well, I disagree with that. That is an argument that the defendants have made, definitely. But I think the point I would like to make is that there's a difference, a fundamental difference between filing a case that's untimely and failure to prosecute. Filing a case that's untimely is filing a case with a procedural defect. And there could be a lot of similar procedural defects, filing in a court that doesn't have jurisdiction, filing in the wrong venue. Those things all are mistakes that lead to the dismissal of a case. But a plaintiff is trying to vindicate their rights, that there's a procedural problem for their dismissal. And the difference is failure to prosecute means you've brought a case, so you've done that part, but then you've done nothing to push the case forward. And so that's the difference. And that's the reason why I think that's treated differently, because that's very beneficial to defendants to have a case on file, have nothing take place in that case. If the savings statute were to apply in that scenario, it could sort of be a recurring loop. Someone could file a case, do nothing for 10 years, it's dismissed, and they could do it again under the savings statute. And that would be very unfair, very inefficient for the courts. That's not really the same when there's a procedural problem, like the statute of limitations issue.
Well, counsel, with respect to the procedural problem, both Texas and New Mexico are aligned with respect to the statute of limitation. The procedural law controls. Counsel knew that. They practice both in Texas and New Mexico. Why isn't that a negligence in the failure to prosecute? They filed the case in Texas after the statute of limitations.
Well, I think the important distinction here is that it may reflect a lack of diligence on the part of trial counsel, certainly. But Zingara says that we don't look at the form of the mistake, the nature of the diligence that was exercised and leading to the first failure. We just look at whether it was dismissed for failure to prosecute.
So Zingara talked about a dismissal without prejudice. Here we have a dismissal with prejudice, which is a final decision.
Yes, and I think the distinction there and I'm glad you're asked this question because I wanted to get into it, is if there's sort of a conflation of the terminology with prejudice and without prejudice and claim preclusion. So as we said in our briefing, yes, the first case was dismissed with prejudice, but the term with prejudice means it cannot be refiled in the dismissing court itself or in the jurisdiction of the dismissing court, but it does not necessarily have claim preclusive effect elsewhere.
Why don't we have to give full faith and credit to that decision as a final decision?
And while we have to give full faith and credit to that decision was that the first case was untimely under the Texas statute of limitations. It was not that that case could never be refiled elsewhere. And I did file a notice of supplemental authority last week. The case is called Simtech. It's a U.S. Supreme Court case. It's not really binding on this court, but I think it has a very helpful explanation of sort of this.
That deals with.
So can I ask you just a question on the savings statute, which says if after the commencement of an action, the plaintiff failed therein for any cause. I want to focus on that beginning part of the statute that says if after the commencement of an action, which has been interpreted to mean the action must be timely commenced. That's where I'm concerned about your argument here. It's less the negligence in prosecution, it's whether this action was timely commenced elsewhere, and therefore you can use the savings statute to your benefit. Can you answer that for me? That's kind of where I'm stuck.
Yes, definitely. So we have argued that our case was timely commenced within the meaning of that precedent that requires the timely commencement of a first action, because it was timely filed with under the New Mexico statute of limitations. And I think that is where we have we're talking past each other with the defendant.
Getting to Judge Matthews' point, statute of limitations is a procedural aspect of the case. And so statute of limitations of Texas governs Texas, and in New Mexico, the same. So while it wasn't filed timely in New Mexico under our 3-year statute of limitations, it wasn't filed timely in Texas under its 2-year statute of limitations. How does the New Mexico statute of limitations apply to a Texas lawsuit when it's a procedural rule?
Yes. Okay. So the issue is that the savings statute, and I'd like to focus on the text of the savings statute. It allows a case to be refiled in New Mexico if a previous case was filed, dismissed, or anything but failure to prosecute, and then refiled within 6 months. And so we have argued that if you look at the plain text of that statute, there is no requirement in that text that the first case must be timely under the statute of limitations of any state other than New Mexico, regardless of where that case was filed. And I'd like to go through it piece by piece a little bit because I think it helps. So to back up, the savings statute, of course, only comes into place when there is a second suit in New Mexico that is filed after the statute of limitations in New Mexico, which is what happened here. So the point of the savings statute is to treat that second case as timely under the statute of limitations, even though it's a legal fiction. It really was not the case. The second case here was late. But the text of the savings statute says, if after the commencement of an action, the plaintiff failed therein for any cause, the second suit shall, for the purposes herein contemplated, be deemed a continuation of the first. So for the purposes herein contemplated in that text means for the purpose of the savings statute, which is to treat the second case as if it was timely filed under the New Mexico statute of limitations, even though technically it was not. Deemed a continuation of the first, that piece of the puzzle means that, again, even though the second case was technically late, we're going to let the date of the first filing be considered the date of the second filing. So our point has always been that this necessarily includes a requirement that the first case was filed within the New Mexico statute of limitations, definitely, because if it wasn't, it doesn't help, because
The New Mexico statute of limitations doesn't apply to a case filed in Texas.
Correct, true. But the point is that the text of the statute does not limit the application of the statute to cases that were filed in the first place in New Mexico. It can apply to cases that were filed outside of New Mexico.
How do you deal with the language in, and I know this is not binding on us, the DeVargas case, the 10th Circuit case, where the court basically says when you file after the statute of limitations, in another jurisdiction, and then you try and refile under the savings statute, that there's nothing to save because the original case was basically a nullity. There was no case because it was not timely filed. How do you address that?
I think the very important distinction in DeVargas is that both the first case and the second case were filed under the New Mexico statute of limitations. So that does not impact what we're saying here. The first case in DeVargas was filed in New Mexico State Court. It was too late. And so then when they came back and they said, we want to use the saving statute to tie it in, it didn't make sense because you can't use the date of the first filing.
But what the DeVargas court said was there was no first case because it was filed after the statute of limitations. If we follow that reasoning, there is no Texas lawsuit. It did not exist. And your filing was after the 3-year statute of limitations in New Mexico. So how do you apply that savings when the first case was a nullity under DeVargas?
I think maybe where we disagree is that I don't believe that filing a case that is untimely is a nullity. And I think that later, I think Zangara sort of disputes that idea. I think the nullity language comes up in some cases, and then Zangara kind of makes it clear that really any procedural defect, it does, as long as it's not a failure to prosecute, you can bring a second
Or
case.
being untimely filed. Zangara requires timely filing.
Well, if I could disagree, I think it definitely has a timeliness element, but what the language is that, I'm sorry, I'm gonna pull it up. The language is that the saving statute extends the running of an otherwise applicable statute of limitations when an action is timely commenced or later dismissed. And our point, where we don't disagree, the words timely commenced in that statement are important because the point is that there has to be timely commencement under the New Mexico statute of limitations, because otherwise we're nowhere. I mean, if the first case is filed 15 years past the New Mexico statute of limitations and dismissed, you can't come back and say, well, I want to use the date of that first filing to satisfy the statute of limitations for the second, because that doesn't help you. And so we agree that there is a timely commencement requirement, but under the text of the saving statute, when we're talking about timely commencement, all we mean is that it has to be filed within the 3-year New Mexico statute of limitations. And if I could, I wanted to make.
But the problem here is neither action was filed within the statute of limitations.
I agree, although, I mean, of course, the second.
So the first case is dismissed for lack of jurisdiction because it was not within the statute of limitations. The second case is filed beyond the statute of limitations. So you got 2 strikes against you. Then DeVargas says you cannot revive that which never existed. That's 3 strikes against you, it seems to me.
Well, okay, so for sure, the first case is filed past the Texas statute of limitations. The second case definitely also filed past the New Mexico statute of limitations, but that is, of course, filed here because that's why we're invoking the saving statute. So I think respectfully disagree that it's sort of a strike against us.
There's no pending act. There's no, to Justice Zamora's point, the action was not commenced. This didn't happen after the commencement of the action.
Well, the first action was, again, looking at the text of the statute. The first action was commenced in Texas.
Dismissed.
It was dismissed, and there was a procedural defect, and that's why it was dismissed. There's no dispute about that.
But it was timely commenced in Texas. And no matter, seems weird to me that we're creating this fiction that, okay, well, we're going to apply New Mexico statute of limitations, even though legally we would not do that, even though legally Texas applies. Because Zangara focused on the except negligence and prosecution language in the statute. To me, the focus right now is if after the commencement of an action language and talking about the commencement of actions, that's the language I'm focused on, which is a little different than Zangara, and that requires a timely commencement. And trying to wrap my mind around where in the statute it says, oh, but by the way, we're going to apply New Mexico law to the action you filed in another state. Where does it say that, and why would we do that?
Okay, so I'd like to make a few points on that. I've already talked about the text. I do want to just briefly reiterate that the text of the statute does not say the timely commencement of an action. And the reason I point that out is because we agree that there is a requirement in the statute that it only applies if the first action was filed within the statute, the New Mexico statute. So I made that point. But I think I wanted to point out some sort of weird results that we get if we look at a different state's statute of limitations to decide whether the saving statute applies. So here the Texas statute of limitations was shorter than New Mexico, but to think about a situation where the first state has actually a longer statute of limitations than New Mexico. So let's say that 5 years after an accident, a plaintiff files a case in Maine where the statute of limitations for personal injury is 6 years. So the first case is then dismissed, and then the plaintiff comes back to New Mexico and wants to refile. Under what we're discussing, I mean, that would be timely commencement under Maine law, but it has now been filed, several years after that case would have expired in New Mexico. And that creates really pretty weird incentives if we sort of follow it through, because then any New Mexico plaintiff who files or realizes, it's 3 years has passed in New Mexico, I'm going to go to Maine, year 5, I'm going to file a lawsuit. It's going to be dismissed. It's going to be lack of personal jurisdiction because this case is not related to Maine. And then I'm going to come back and invoke the saving statute because technically it was timely commenced in Maine. And that is a really weird result.
But it's dismissed. And 37-1-14 assumes a pending action because it speaks to negligence in the prosecution of an action.
I think
In your hypothetical and in this case, neither case existed.
And I think, that's just where I disagree, because I don't think the first case just being dismissed on a timeliness defect makes it a nullity any more than dismissal for lack of subject matter jurisdiction makes it a nullity, or dismissal for improper venue makes it a nullity. The fact that statute of limitations is a procedural defect.
Counsel, where I'm having trouble with your argument is Maine doesn't have jurisdiction. So the case can't be filed in Maine. It can't be timely commenced in Maine because there's no jurisdiction in Maine. So that's not a really good analogy to me.
Well, I think where I disagree is that it can be filed in Maine. It will be dismissed in Maine. But that, dismissal for lack of personal jurisdiction, that's the basis of, several of our opinions that reach the saving statute. That's Barbeau, that's, I believe.
The case we have in front of us is a case where Texas did have jurisdiction. And our law says it's the law of the forum that determines statute of limitations. Texas was the law of the forum and chosen by the plaintiff.
Yes, but I think our point is that there's no reason to treat the statute of limitations defect in the first case as any different than like filing in the wrong venue, for example. Yes, it was untimely, but untimeliness is a waivable defense. A case can go forward even if the statute of limitations is blown, if everyone agrees to do that, or if the defendant doesn't snap to the issue. So it's not a nullity, to Justice Vihill's point, because, you could go all the way to judgment in a case that has a statute of limitations defect because maybe no one raises it. It's a verdict for the plaintiff. You wouldn't take that away because there was a statute of limitations defect in the case that you realize on appeal. It's not a nullity. It's just yes, there is a procedural defect. And
Isn't that but the facts of this, would it be a different analysis if came back to New Mexico and filed at 2 years, 6 months instead of post 3 years?
yes,
That's different. Your argument could hold weight if that happened, but it was not filed in New Mexico timely either.
and I
It
think
was filed in a different state timely under New Mexico statute of limitations, but isn't that procedural fact important?
well, I think it's important in the sense that we agree with the premise of the question, which is that if a case were initially filed in Texas and dismissed for lack of statute of limitations in Texas, that 3 years had not passed in New Mexico, we absolutely could have filed in New Mexico because, and I have a quote, that the traditional rule is that expiration of the applicable statute of limitations bars the remedy but does not extinguish the right. And so dismissal, doesn't have any preclusive effect on like a state with a longer unexpired statute of limitations. So we were, so the dismissal of the first case did not mean that we could not go anywhere else. It was not a preclusion of us from filing anywhere. We did file in New Mexico past the New Mexico statute of limitations, but that's why we invoked the saving statute.
With regard to the saving statute that you recited, there's language, I think you cited that it must be a continuation of the first.
Yes.
You agree that's in the saving statute?
Yes.
How can it be a continuation of the first if it was dismissed in Texas? And I think that's where we're struggling also. It's a dismissal with prejudice. And as I understand it, having looked fairly recently at venue, that's like it didn't happen. How do you wrestle with the continuation of the first if it's dismissed with prejudice?
Well, so maybe 2 points. Within the saving statute, I believe that the phrase continuation of the first, again, means that you can use the date of the first filing to satisfy the New Mexico statute of limitations for the second filing. You get to import that date and use it for the second one. I have forgotten.
But that's what you're doing.
That is what we're doing. And our point is we're allowed to do that. So there's no problem. The fact that the first case was dismissed in Texas does not prevent us from using that date to satisfy the second statute of limitations any more than the first dismissal for lack of jurisdiction would prevent us from using that date. And we know that is allowed because that's what Zingara tells us. I think maybe if it's okay, I would just like to give the court a little context because maybe it helps sort of lay out exactly what happened here. So again, the purpose of the statute is to give leniency to plaintiffs who have made a procedural mistake in the first case. Here, there were 2 available forums for plaintiffs. So the parties were Texas residents, so Texas is a perfectly reasonable forum. But the injury happened in New Mexico, so New Mexico also was a perfectly reasonable forum. And that, that happens a lot where there's multiple venues or multiple jurisdictions, so that could be appropriate for you to file. Here, plaintiff chose to file in Texas, where New Mexico substantive law applies, made the mistake of believing that that would include the New Mexico statute of limitations. It did not, but believing that it would include the New Mexico statute of limitations, the case was filed 4 months before the New Mexico statute of limitations expired. Then nobody raised statute of limitations as a defense at all in the case until after the 3 years had passed. So plaintiff really had plaintiff made a mistake and then had no particular awareness of the mistake until after the 3 years. So he couldn't just say, my bad, let's go to New Mexico, which we all agree would be perfectly allowed. That couldn't happen. So the 3 years had passed. And so he knows there's a procedural defect and he needs to invoke the saving statute so that he does not lose his substantive right to bring his case because of that initial mistake. And so whatever we think about why he made that initial mistake, whether it was completely unreasonable, Zingara tells us that that does not matter. If there is a mistake and you can refile within 6 months of dismissal, then you're allowed to go forward. I wanted to make one more point about why we believe that when we talk about timely detention, we're talking about timely detention under New Mexico law and not deferring to any other state's statute of limitations for making that determination. And that is just the policy, New Mexico policy. So the New Mexico legislature has decided that an injured plaintiff should have 3 years to begin a personal injury lawsuit. And the legislature has decided that that gives everybody the right balance. Injured people have time to find a lawyer and bring their claim, investigate. And defendants are not prejudiced because within 3 years, they are told that there is a lawsuit against them. Evidence is not going to fade, so it's the right balance. Of course, that policy is different than other states. Some states have very, 1 year statutes of limitations to 2. And then, like I mentioned, Maine goes all the way up to 6, which is very long. But New Mexico made that specific choice. And then the saving statute is there to ensure that someone who commences a lawsuit within that 3 year statute of limitations doesn't lose their substantive right altogether because of a procedural mistake. So to limit the application of the saving statute to situations where, and I can see, may I finish?
Just wrap up, yeah, thank you.
To limit application of the saving statute on any other statute of limitations would essentially be displacing New Mexico policy about what we think is fair with the policy of it. Thank you.
All right, thank you, counsel. So you have 15 minutes. You may enter your appearance. Proceed.
Pretty fancy, huh?
The Cadillac. That's the best. Do that.
Brian Shoemaker, a native priest, on behalf of Wildcat Oil Tools. May it please the court. This court should affirm the decision in the Court of Appeals. The Court of Appeals got the ruling right in that case. The decision in the Court of Appeals was founded on this court's prior decisions in GM Architects and US Fire. Further, the Court of Appeals ruling is fully constant, while before this court's decision in 2024, it's fully constant with this court's ruling in Sephora. In sum, the appellant's case is barred by the New Mexico statute of limitation. The incident occurred in October of 2017. The plaintiff filed in New Mexico in May of 2021. That's well outside the statute of limitation. The trial court correctly dismissed the lawsuit here in New Mexico. Further, the plaintiff does not qualify for even the application of the saving statute.
Can we walk through that, please?
Absolutely.
So the statute begins if after commencement of an action, doesn't say New Mexico action, it says an action. The plaintiff therein fail for any cause. Doesn't say, it says any cause except negligence in its prosecution. So that the phrase any cause can include a statute of limitations, it seems to me. And then it says a new suit is commenced there 6 months thereafter, which happened in this case. The second suit shall, for purposes herein contemplated, be deemed a continuation of the first. So why, walking through that with that rationale and those additional observations, why does not 37-1-14 apply to the second filed case in New Mexico?
We borrow from what I believe that this court did in Sangara and citing in what the court did in G Marketplace, where they said on cases timely filed, and the timely filed has to be within the jurisdiction in which it is filed. When plaintiff goes shopping, and in this case, the plaintiff had multiple, or already admitted, they could go to Texas or New Mexico, they could go to federal or state court in either of those locales. But when they went and they stopped shopping and they purchased the jurisdiction of Texas, then they became subject to the law of Texas. And then they become subject to what happens there in Texas. The Texas court said there's no jurisdiction.
What do you,
they didn't timely file.
counsel, what do you rely on for your statement that they have to apply, timely filed means in the jurisdiction where they filed rather than the New Mexico statute?
I think that's the only, that interpretation is the only reasonable interpretation, because if we were to take a plain meaning statutory principle and apply it, if we were to look at what the purposes of the statute are, to apply the New Mexico statute of limitation to a court in Texas on a procedural issue, it contravenes what the purpose of the statute is, because you're trying to benefit who filed timely in the first instance, and Texas says it wasn't timely filed.
Right, but what about Ms. Benvenue's argument that the New Mexico legislature has spoken, and their belief is that 3 years is the time that a plaintiff should have to file a personal injury action?
Absolutely. That is New Mexico statute of limitation.
So why shouldn't we consider that in deciding when the saving statute comes into play?
Because plaintiff didn't file in New Mexico first.
Why does that matter?
Because it matters as a legal consequence where a plaintiff subjects themselves to jurisdiction. Plaintiff is in the unique role that they get to choose when they go shopping, right? Forum shopping, which is permitted in terms of before you buy. They get to choose where they're gonna file, and when they make their assessments, then they get to go, well, what are the statutes of limitation? What are the laws that are going to apply? Where are we? So they get to the where, when, and how is in the plaintiff's control. And
Can I ask you a question? I think I understand what you're saying. I just want to make sure you're not taking it further. You're not suggesting that you have to file in New Mexico first for the saving statute to apply. For example, if they filed in Texas and it was dismissed for some reason other than the statute of limitations, but it was timely filed, then they could apply the saving statute.
Zangaro applies.
Okay, I just want to make sure. I thought you were saying you always have to file in New Mexico first.
Not
Okay.
at all.
Okay, thank you.
So I don't know, Justice Vargas, if I answered fully answered your question, but we believe that it has to be in the jurisdiction that the plaintiff first subjects themselves to, where they file first, because that is the court that's going to have the applicable procedural law with respect to this issue of statute of limitation, right? I understand that Zangaro was more about, in fact, the court expressly made a note in multiple places in the opinion that there was no issue about the timeliness of the filing in Zangaro. That was not at issue before the court, whatever. And so they were able to assume that it was timely filed, and therefore they made the equation of negligence in the prosecution and failure to prosecute. Got that clear? That makes sense. But in this case,
But your argument ignores the plain wording of the statute. If the plaintiff failed therein for any cause except negligence in prosecution, any cause includes statute of limitations, or does it?
well, so again, I go back to the plain meaning. On a plain meaning analysis, I don't think it could mean that. I don't think that under the purposes of the act, it could mean that. And I think it would create an absurdity. The court's language, not mine, but I think it creates an absurdity, almost a legal whiplash of, I'm sorry, what? You can file late in the jurisdiction of first choice, and that's not going to be considered untimely?
In that jurisdiction.
In that jurisdiction, how is that possible?
But think through the rule you're asking us to write in all circumstances. They go to Texas, they file 2 years, 1 month. Texas court says 2 years, you're out of luck. They're still alive under statute of limitations in New Mexico, right? They can come to New Mexico and file 2 years, 10 months, but they file in Santa Fe instead of Lee. Are they entitled? Are you suggesting they're not entitled to the saving statute in New Mexico?
That's an interesting question, Justice, and I think in this case, it's a hypothetical question.
It's not hypothetical because we write rules. So
Absolutely.
So what we write applies to you and everybody.
Absolutely. And so in this instance, I would first start with King v. Lulu. Okay. King v. Lulu on this court made the equation. They said the court should not distinguish between a party that fails to take action before the expiration of a statute of limitation and a party who files before the statute of limitation but thereafter fails to take action. And in this particular instance, what the court would then be saying is what happened in Texas didn't happen. It was preseason, spring training. It wasn't a real case. And then what we're going to say is a district court in New Mexico who receives exactly the scenario that you're proposing, in essence, is going to overrule another district court out of Texas on Texas law, saying our New Mexico law is going to apply, and therefore Texas, what you should have applied the New Mexico law in Texas. That doesn't make sense.
Fair enough. So you're saying no?
Absolutely.
Okay.
With extra words. I'm a lawyer.
You could just say no.
Yes. All right. That's what my wife would say.
I appreciate that. Can you address the supplemental authority? What role does, if any, this, the preclusive effect of the dismissal with prejudice, or do you even assert that necessarily?
Well, we have a question about the timeliness of this presentation, but more importantly, our first point of response would be, it's not controlling. Now, we recognize that it's an opinion from the U.S. Supreme Court. The U.S. Supreme Court's important, but the case facts there are more of there. When you look all that's there, there's federal diversity. Federal diversity is not in front of us. There's even federal question issues and other statutes that were raised. And so in terms of its direct applicability, we would argue that it's not directly controlling, and therefore it's not it shouldn't be considered as supplemental authority in this case. But if you want me to still answer, I can.
Well, it centers some of the questions we had for plaintiff. And it goes to my previous question. The dismissal, I don't know whether there's preclusive effect. The effect of the dismissal seems to be that it did not exist. And therefore, to then employ the New Mexico statute of limitations. I mean, the facts of this case are that it was post the 3 years New Mexico statute of limitations. So I don't know if there's necessarily preclusive effect. I think my main concern for plaintiff's argument is it's hard to invoke the saving statute. But you answered the question.
Any other questions?
Does statute of limitations, a subject matter jurisdiction bar? In other words, is in New Mexico, well,
We think it is a jurisdiction. It's a jurisdictional bar.
is it a subject matter jurisdiction bar either in Texas or New Mexico or both?
And honestly, I haven't looked at it in that framework. We, as the court was having this discussion with plaintiff's counsel on the front end, well, the Wildcats interpretation of it is consonant with that, in that we think that it's pretty clear that when you file in a jurisdiction, you become subject to that jurisdiction. And typically the rules of civil procedure are going to apply.
I understand that, but I'm just going beyond that. A court can have subject matter jurisdiction, but dismiss the case for failure to comply with statute of limitations.
We think that there is a strong argument in this case that there's a preclusive effect. It was a motion for summary judgment. There is a case where New Mexico Supreme Court, where there was a water rights case. Let's see. Yeah, it was in Cartwright, the 61 case, where there was a hearing on an affirmative defense. And the hearing on the affirmative defense was effective to constitute res judicata, thereafter barring a subsequent trial.
Other questions? Thank you, counsel.
Okay, well, with that, in conclusion, we believe that the search should be quashed. If the court is inclined to write an opinion that it should be non-precedential, Both lawsuits were filed late according to the respective statute of limitation. We don't think the plaintiff qualifies for the saving statute. We would say, according to King v. Lujan, that even if the court were to say that the saving statute applied, that the failure to file timely in the first instance, according to King v. Lujan, was in fact a negligence in the prosecution. Thank you.
Thank you.
May it please the court.
See,
Stephanie Demers on behalf of Ranger Energy Services LLC, the co-defendant in the case, the entity that also filed a motion for summary judgment based on the statute of limitations violation and the Texas action that was dismissed with prejudice. And I don't want to be redundant, and I certainly don't want to waste anyone's time, but there's a couple of things I would like to maybe loop back on, and including Justice Zamora's early questions and some of the questions from Justice Vargas and Judge Matthew regarding the sine qua non of operation of the saving statute, if we want to use French, or the prerequisite, if we'd rather call it that. There has to be a timely filed first action, or the statute is inoperable. And we know that.
so I'll ask you the horrible hypothetical I asked the Cal Oil Tools. In a kinder way, I'll ask the hypothetical I just asked on the saving statute. I just want to make sure I understand your collective argument. Because I think your argument is, and you can tell me if I'm incorrect, if they would have come back to New Mexico at 2 years, 10 months, they do not get the benefit of the saving, and then they get dismissed for, let's say, venue first and instead of Lee County. They could not avail themselves to this saving statute because they invoked first Texas on the 2-year statute of limitations. So they, in essence, only had 2 years, 6 months.
No.
That is not your position.
That is not our position.
Okay.
In your hypothetical, Justice Thompson, if I understand it, if they filed the Texas action beyond the Texas statute, and then they came to New Mexico and filed an action within the New Mexico statute of limitations, and for some other reason, I perceive your question to be, does the New Mexico action then become the first filed action? Yes.
Okay.
There has to be a timely action in the first instance, we should say, rather than a first file. Perhaps that makes it more clear.
Okay.
That there has to be a timely filed action to constitute the springboard into the savings statute. Because what the savings statute, the reason that we know that is the prerequisite is because we have to read the entire statute. This is a different question than we had in the thing, you all had in the Zangar case. It is distinguishably different because in that case, there was a timely filed action and you were looking only at how to address the concern with the minutia and the negligence that evaluations have been going on and the myriad of case law, Barbo and the others, Amica, that were potentially extending it beyond its, the exception beyond its. But here we just have a very different scenario. What we have here is, as the de Vargas court said best, and Ranger argued strongly to the Court of Appeals, and the Court of Appeals adopted in its published opinion, that you have to have something to continue or there is no purpose. You have to read the statutes in tandem. We have the statute of limitations and we also have the savings statute. And the purpose of that savings statute is to provide a grace period, if you will, for a litigant who files.
But that ignores, that argument ignores, I keep coming to this point and tell me where I'm wrong. It ignores the language of the statute, which says if plaintiff therein fail for any cause except negligence in its prosecution. A dismissal for failure to comply with the statute of limitations is a failure apart from negligence of the prosecution.
I do see your point, and I hear
And,
your
and,
argument.
and let me add to that, the question I asked before, does statute of limitations equate to subject matter jurisdiction? If my question is clear.
I'm sorry.
So let me ask it this way. Did the Texas court have personal jurisdiction of the parties and subject matter jurisdiction of the case?
In Texas. I don't know that we got that far because there was a violation of statute of limitations. So I haven't evaluated.
Well, maybe if the court did not have subject matter jurisdiction for whatever reason, your argument seems to me would have greater force. But if the court had subject matter jurisdiction and personal jurisdiction, then we bring in the language of the statute that it failed for a cause except negligence in its prosecution.
But you have to read the latter portion of that statute as well. And what the reason that
It's a continuation of the first.
there has to be something to continue. That it would be that
They had subject matter jurisdiction. There is something to continue. In other words, you're saying that dismissal for any reason means there's no case.
what I'm saying is that it'd be just a little bit different. And maybe forgive me if I'm misunderstanding your question, but what our position is that we don't get into what would constitute negligence in the prosecution. Because we just don't get that far unless we have a timely filed action that we're trying to extend through operation of the statute, the savings statute. So that the purpose, and maybe I can make my point clearer by explaining that, my perspective, I'm not really sure why we're here because it seems quite basic. The plaintiff has not offered any case from any jurisdiction where a timely filed lawsuit, where the operation of that state's savings statute, and I believe there are 46 states that have some version of a savings statute, and we don't have a single case before the district court, before the appellate court, before this court now, where there has been operation of a savings statute when the first case was untimely. And it is because it is a matter of the purpose of the statute. So, I mean, we're talking about timeliness here. That's what these statute of limitations and the savings statute address, is when a case will be timely. And we have the hard deadline in the statute of limitations ameliorated in some circumstances that the court has now clarified somewhat in the Zangier case. But what we don't find is any case anywhere from any jurisdiction with all of these states having savings statutes. And the reason is that the purpose of it is to extend an otherwise timely suit that is dismissed for any reason other than negligence in the prosecution. But it's to extend it. It's to extend a timely suit, not to create room for, essentially what the plaintiffs are arguing here, they're asking the court to adopt a fate. They're asking the court to look at the filing in Texas and pretend that it was filed in New Mexico.
So if you filed in Texas timely, but the Texas court said, I don't have subject matter jurisdiction, and dismiss it. And under your argument, because it was timely filed, the second filed suit would be a continuation of the first.
So if the action was filed timely in Texas?
But dismissed for lack of subject matter jurisdiction.
Okay.
Then subsequently filed in New Mexico, just like here,
And then it was filed?
in New Mexico, after the New Mexico statute of limitations. Under your argument, it would be, the statute would operate to be, the New Mexico case be a continuation of the first. Because it was timely filed in Texas.
I hadn't thought of it. I had not looked at it that way.
That's why the language of the statute, at least to my reading, it says for any cause, which includes statute of limitations.
Right. So then would you imagine that we would have seen this work its way? There would be some appellate opinions where there was an untimely filed case in the first instance, but the savings statute operated to date. And we just don't have that. What we're looking at are the facts here.
We're looking at the language of the statute in this case.
Right, and the context with which it was enacted, which is to save an otherwise timely lawsuit. You can't read the first portion of the statute in isolation, and that's, I guess, leisure would be a case that this court relied on in the Zangara case, which applied deeply here. You have to look at the entire statute, the purpose of the statute, and take it within its context. And what we have is a statute that's in the saving statute. What we have is a statute that is designed to save an otherwise timely filed case. So you're saying if you're asking your question, Justice Vigil, if I understand it, is if the case had been timely filed in Texas and dismissed for another reason other than untimely, then the litigant came to New Mexico. Would New Mexico save it? That would depend on the Zangara type analysis, which is whether that would constitute negligence in the prosecution. And that's a different question. So I don't think the court needs to answer that question in order to find that the Court of Appeals did not err in determining that the lack of a timely filed action prevented application of the saving statute in this case. And that is what the court said, and that is what we would ask this court to affirm is the rule that there has to be a timely filed action. And that's the question before the court. And I don't think that the court needs to go further and determine what might happen had it been something different. Because then if there was a timely filed suit, Justice Vigil, then we would be within the realm of the saving statute, and the evaluation and the analysis would be whether it fits the exception and whether it constitutes negligence in the prosecution. And the circumstances under which that could be argued, I would say, are also met here. And that is because in the Zangara case, this court took the opportunity to say that it is essentially means failure to prosecute. But what that also means is failure to take timely steps to bring it to completion. It's all about the timeline. So if the court is reluctant to make a hard rule, which we would ask that it do, that a timely filed action is a prerequisite to operation of a saving statute, we can also get there another way, which is if the court is reluctant to make that rule, then we can apply the rule that comes out of Zangara, as we also argued in the Court of Appeals, and that would constitute failure to prosecute. It's a failure to timely bring it to a conclusion. What could fit more squarely within that definition than failure to timely bring it? Yeah. And then we get back to the de Vargas language, which is illustrative of the absurdity of what the plaintiff is asking the court to rule here. The plaintiff is asking the court to create a fiction that because this case could have been filed in New Mexico when it was filed in Texas by choice, that we should pretend it was filed in New Mexico in order for the saving statute to operate as saving. And that is illogical. And that is the very thing that the excerpt from de Vargas that Ranger Energy argued so heavily in the Court of Appeals. We don't have any case where that has happened in any jurisdiction, including, all 50 states, at least 45 of which have some measure of saving statute. And there's a reason. The absence of that case law for the plaintiff to bring to you is because it doesn't work its way through, because it's so patently obvious that the purpose of a saving statute in its inception is to save an otherwise timely suit. So it gives a grace period. You file it timely, and then it's dismissed for any other reason, any reason other than the negligence in the prosecution, which we now know has a narrow definition.
Mr. Merce, what would be the situation if the motion was a 12B6 argument plus the statute of limitations?
I'm sorry,
What would be the situation if the trial court would have dismissed for failure to state a claim under 12B6, but there was also a request to be dismissed for statute of limitations? The court would say, we don't need to get to statute of limitations because I'm dismissing it under 12b6. Could they then come over to New Mexico and file because the court hasn't ruled on the statute of limitation?
I think it would depend on the statute of limitations. If there is no determination that it's untimely, I mean, I think that the litigant would press for that.
So would Sangiro say you could come over to New Mexico then?
So would an also untimely lawsuit dismissed for under Rule 12b6 qualify for savings operation? If there is no determination that it's untimely, I think those arguments could be made. I'd have to think it through and read the cases a bit more with that, but I don't know that our argument here today would preclude. The key here is that it was dismissed for violation of the statute of limitations and therefore untimely. So there's nothing to save under the DeVargas reasoning and all those.
All right, thank you, counsel.
Thank you.
5 minutes rebuttal.
George, that's okay. I want to start with this idea about what other jurisdictions do and this idea that there's no case anywhere where this has happened. I want to start by saying there are no other cases in New Mexico on this point. This is new for New Mexico. And that's because every other case we've had to date has really been where both cases were filed under the New Mexico statute of limitations. The only exception is Barbeau, and Barbeau has been overruled for other reasons. But if we look at Barbeau, the first case was filed in Oregon, the second case in New Mexico. And actually, the Court of Appeals looks at the New Mexico statute of limitations when it's talking about whether the first case was timely commenced. It says the first case was commenced 2 days before the New Mexico statute of limitations expired. I don't think that's really here nor there exactly, but if anything, it's really the assumption was that we're looking at New Mexico statute of limitations. But to this idea that nowhere or anywhere in the country has this kind of sort of absurd reasoning, that really is not true. And we didn't really get into this in the briefing because this kind of became an issue only late. Negligence in prosecution was the issue until the end. But in preparation for today, I found there's lots of states that have said that the state will apply its own statute of limitations in deciding whether the first case was commenced timely in order to allow.
Is that in case law or statute?
Case law. So, and I could give the court a few examples because I think it is helpful. So one is the case is called Allen versus Greyhound Lines, the Ninth Circuit case 656 F 2nd 418, and the Ninth Circuit was applying Montana law. The first case was filed in Utah. It was dismissed untimely. It was refiled in Montana using the saving statute. And the result was that it was saved. And the court said, the Montana legislature has expressed its interest that plaintiffs shall have the opportunity to file personal injury actions at 3 years after their cause of action arose. It is therefore unlikely that the Montana legislature intended the applicability of its saving statute to turn on the limitation period of a foreign state. To do so would frustrate the very interest the saving statute was enacted to protect. So that's really exactly what we're arguing here. I do want to back up and say, every state has slightly different language and different history, so I'm not saying it's not true that no other state reached this result. Maybe one more example, LaBarge Inc. versus Universal Circuits, it's 751 F sub 807, and it's a federal court applying Arkansas law. And the Arkansas, or I'll just read the quote, in light of the liberal construction given the saving statute by Arkansas courts, and the purposes underlying the saving statutes, we conclude that Arkansas would apply a saving statute to actions originally filed in foreign states, as long as the original action was commenced within the statute of limitations specified similar action causes of action under Arkansas law. So there are plenty of examples all across the country reaching this result. There are also examples going the other way. I do not want to be misleading, but it's this issue comes up irregularly. It certainly has not come up in New Mexico. But it's not as if there's no court anywhere that has reached this result. And our point is just that we have to look at the text. Justice Vigil's, what you have been saying today, that the text just says, if after the commencement of an action, the plaintiff fail for any cause, then the second suit shall, for the purposes herein contemplated, be deemed a continuation of the first. So nowhere in the text of the statute is there any requirement that the first case has to be timely filed in the jurisdiction where it was filed. There is no textual support for that. Very quickly, I wanted to address the argument or the conversation about whether the statute of limitations is a jurisdictional bar. And it is not. It is a statutory requirement and it's a defense that can be waived, but it is very different than a jurisdictional bar. And here, the Texas court did have personal jurisdiction over the defendants. So they had general personal jurisdiction. Both defendants were Texas residents. And the court had subject matter jurisdiction because that just means that the court had the power to hear that type of suit. And Texas trial courts are courts of general jurisdiction.
Does Barbeau indicate whether or not that's sufficient for a first action being, for a subsequent action, for a first action to be deemed continued by a second filed action?
I don't
Presence of personal and subject matter jurisdiction.
I don't believe Barbeau directly addresses that point. The first dismissal is for lack of personal jurisdiction in Barbeau, and the case was not saved, but that was really about negligence in prosecution. But I don't think Barbeau really addressed that, but we certainly believe that here, the Texas court absolutely had jurisdiction, so did the New Mexico court.
Thank you, counsel.
Thank you very much.
In the matter of S-1-SC-40442, I want to thank counsel for their papers and oral argument today. Court is in recess until 10:30. This matter is submitted.